We'll go ahead and get started. Really glad to see such a great interest in this topic. It's something I've been working on for a number of years. I'm going to start by introducing myself. My name is Alex Kornya. I am currently the Litigation Director and General Counsel at Iowa Legal Aid. I will say that I've been having some issues with my headphones, so if for some reason my sound cuts out, please just send me a chat so I can do something to rectify it. So please, patience in advance for any technical issues. So my name is Alex Kornya. I'm the Litigation Director General Counsel at Iowa Legal Aid. I've worked at Iowa Legal Aid since 2008, going on my 13th year with the organization. Was a staff attorney out in Dubuque for a number of years before coming to Des Moines in 2013. Right now, my job is to sort of supervise the legal work that goes on across the state for Iowa Legal Aid. I will say also that I have been working on the issue of court debt. In other words, money that people owe to the system because they have had criminal justice, or in some cases, civil or juvenile justice involvement. I've been working on this issue since 2009 on both a state and then also national level. This has become an issue that I think has really grabbed the national attention, especially after the events in Ferguson, Missouri back in 2014, where court debt played a really huge role in sort of the dynamics that drove the dysfunction in Ferguson. But I think, we have been working on it here at Iowa Legal Aid for since 2009, when there were some legislative changes that really made court debt something that drove some of the other types of issues that Iowa Legal Aid deals with, like evictions and foreclosures and utility shutoffs. And because we are an anti-poverty organization, a lot of our clients come to us and they present with issues that are emergencies. They're going to lose their home potentially within a very short period of time. Their access to heat or electricity or running water, those kinds of cases, their car and might be facing a repossession, sort of basic necessities in our society. And however, even though our clients normally come to us with these emergencies and our focus is first and foremost to deal with that emergency, we also try to look beyond the symptom to figure out what the underlying problem is. How can we make people self-sufficient? How can we make sure that people are never eligible for our services again because they were able to actually maintain a basic income and protect these basic assets? And more, starting in 2009, we began to see court debt as one of the major drivers of poverty and something that we simply had to address if we were going to deal with those self-sufficiency issues and those root cause of poverty issues. First of all, just a word about Iowa Legal Aid. Iowa Legal Aid, if you don't know who we are a statewide not-for-profit law firm. We serve low-income folks, the elderly, and other vulnerable groups. We cover all 99 counties in Iowa from 10 regional offices in Sioux City, Council Bluffs, Mason City, Des Moines, Ottumwa, Waterloo, Iowa City, Cedar Rapids, Davenport, and Dubuque. And we cover and provide legal assistance and legal education without charge in a number of different areas that range from family law to housing, consumer protection and debt collection, tax, education, public benefits, and as we're going to talk about today, collateral consequences work. In other words, the parts of a criminal case that last beyond the end of that guilt or innocence phase of the case. By 2019, we closed over 15,000 cases. We closed more in 2020. Don't get me started about what kind of year 2020 was for our clients. That's another presentation. So I also want to talk a little bit about a specific project at Iowa Legal Aid that I have been involved with over the years, and that is our Race Equity Project. The Race Equity Project is sort of the centerpiece of our collateral consequences practice. In other words, helping people deal with those after effects of criminal justice involvement. So this was something that was conceived of by Iowa Legal Aid's Internal Race Equity Committee in 2016, which in general looks at ways to address racial justice issues to the extent that racial justice informs and drives poverty. We can't be an anti-poverty organization without looking at those sorts of issues. And so this is an idea of probably the first project conceived of by the Race Equity Committee, focusing on communities with statistically significant disparities for poverty, unemployment, and incarceration rates for African Americans here in Iowa. The idea that we could do something to help reduce those barriers that follow people after that criminal justice involvement, then that is going to help us with the other sorts of things that Iowa legal aid is more traditionally dealt with. In other words, the evictions, the foreclosures, the utility shutoffs. I'm going to check the chat here just to make sure I didn't lose my sound, or just to see what we've got here. And just curious if the Iowa legislature keeps cutting your funding as it is other services for the vulnerable. Our state appropriation is under the Attorney General's, sort of encompassing the Attorney General's budget. And thus far, over the last few years, we have managed to avoid significant funding cuts. I will also say, though, that the future is very uncertain. 2020 has made me hesitant to make predictions about what's going to happen next week, as opposed to in the legislative session. We'll see what this year brings. Currently, under the governor's budget, we're in status quo, which we're very, I think, lucky and thankful for. I think we've hopefully been proving our worth during the pandemic with some of the things that we've been doing, but that's just my perspective. And then Edward Gallagher makes a shameless plug as a member of the Iowa Legal Aid Foundation board. I really appreciate that, Ed. Thank you very much. So let's talk here a little bit. So to go back to our Race Equity project, the way that we have been doing this work has been primarily through clinics, where we actually go to the communities that are most affected by these issues and make connections with organizations who are already serving these communities and meet people where they are in their neighborhoods. It is a volunteer-powered project. Most of the attorneys who work on these cases are volunteer attorneys from all walks of practice, as well as other non-volunteer attorneys. They have been some of the most satisfying events that I have personally been a part of at Iowa Legal Aid. Our largest clinic, we served 150 clients in Cedar Rapids back in September of 2019. I don't know that we ever do that many in one day again. That was fun to try to see what our limits were, but in general, they tend to be more frequent but smaller events. And since 2017, we've done 30 of those and served over 2,000 clients in this area alone. So let's talk about court debt a little bit, what it is and how does it affect the lives of the people that Iowa Legal Aid serves. So court debt as a general term, is something that can be owed in criminal, but also juvenile and civil cases in many instances as well. It can be owed even when a criminal case is dismissed. This is one of the big issues that we currently have that we've been litigating a lot. And we'll talk a little bit more specifically about this later. But I think there's a lot of misconceptions that this is debt that is owed by people who have been convicted of a crime. And there are millions and millions of dollars on the books at the moment for people who actually have never been convicted of a crime, either because their case was dismissed or they were acquitted of their charges, or the case was never criminal to begin with and it was a juvenile or civil case. Another really important thing to keep in mind is that a lot of people use the word fines to describe court debt. And that's one thing I would like folks for this presentation to walk away from this presentation not doing anymore, because fines are a very specific type of debt that someone owes as punishment. But the reality in Iowa is that most court debt is actually something that someone owes for a service that's provided as part of the system. However, for example, how many people think that a public defender is free? I wish I had a poll on the Zoom because I would actually like to know how many people. I'm going to tell you the answer. In general, a public defender is not free in the sense that you never have to pay for that attorney. Iowa actually has one of the harshest compensation statutes. So after the case is over, going after folks to pay back the state for the dollar for dollar cost of their defense, win or lose. And those amounts are one of the things that really drives court debt as a major cause of poverty, far less than someone who has sort of literally been assessed a payment as a punishment, sort of maybe in lieu of jail or in addition to jail. There's also other types of payments that someone might owe. Victim restitution, which is a really important topic as well, and has completely different dynamics. Jail fees, so the money that someone might pay because they can't afford bail. In many counties, people who can't afford bail will have to pay a nightly fee, essentially because they are staying in pre-trial. We kind of just talked about this, but things to think about, again, don't call it fines. Fines are just one type of debt one may owe, and usually a small part of the whole. So I think we've talked about that really. I think one thing, this is a graph that is compiled from information, public information that the judicial branch has put out there about accounts receivable. And one of the things that I think is amazing about this graph, I have a social scientist friend who finds this graph amazing because she says a straight line like this without dips and crests and troughs almost never occurs in the natural world. Because there's always some external factor that is affecting whatever it is you're trying to measure. You isolate like one particular type of number. Think about all the things that have happened in Iowa and in the world since 1998. How many recessions have we had? At this point, there's at least two. Maybe we're in our third in that amount of time. Think about all the changes in the law. Changes in policy, changes of who's been in charge of government. All of these things, none of them really seem to affect this line, which is just a straight line going up and up and up with no, discernible fluctuation. And we'll be interested to see what 2020 and 2021 bring, given some more recent changes in the law, which I think actually might raise that amount. We might finally see some fluctuation. Unfortunately, I think it's just going to be an increase in the rate. So we talked a little bit about the different types of debt one can owe in a case. And I had this illustration to kind of show how the cost of being poor is really amplified through the way that our laws are currently set up. So we're going to use an example of a former client of mine. This is a client who I represented in a public housing case. And she was receiving and had received for the last few years a minimal amount of supplemental security income. So she actually received the 90% of the maximum amount, which was $720 at the time, because she was paying off an overpayment. And despite that, she had been paying rent at a non-assisted unit at the amount of $500 per month, every month on time for 2 years. She never missed rent, and she never late on rent. However, that left her with very, very little money to be able to pay for things like food, medicine, utilities, all the other things that you need to survive. And from time to time, she shoplifted food, which is not, it's a crime, and she was charged and she was assessed penalties for that. But one of the things I'd like to illustrate is the difference between someone who had that same set of facts and then something that was more like my client. So let's first talk about someone who's not indigent, who is not low income, who has been picked up on a shoplifting charge. Now, in my client's case, as in this example, this was the third time in a 2-year period. So even though it was a small amount, which is how the seriousness of theft charges based on the amount of the property that was taken. Even though the amount in this example was only $30 worth of food, because it had happened 3 times in 2 years, it's an aggravated misdemeanor. Okay, so what we have in this first example for the person who's not indigent is a minimum fine under the law for an aggravated misdemeanor of $625. Could be more, but in this case, we're going to just say, for purposes of the hypothetical, the minimum $625. $30 of victim restitution to repay the cost of the food, and then a $100 filing fee, and let's say 2 days of court-reported fees, $40 a piece, at court costs of $180. Okay, and so now we've got a subtotal of $835. Now this is under the old law, which had a 25% collection fee. We've actually just recently changed. I just realized this slide here needed to be updated, but we're going to go with 25, currently 15%. But let's say the person is unable to or doesn't pay the 835 subtotal before 30 days have expired, then that person is going to have a collection fee added on of $209 for a grand total of $1,044. Hold on just a moment here. I want to make sure. State of Iowa cut the judicial department budget. That is true. So for someone who is low income, like my client, their debt for the same case, for the same facts, looks something like this. So they have the same fine, we're going to say minimum fine of $625, the same victim restitution, which is based on the amount of the food, which is $30, and the same court costs. However, my client in this case relied on indigent defense counsel, public defender, or contract defender in order to defend her in this case. And let's say that indigent defense counsel charged the cap for an aggravated misdemeanor, which is currently actually $1,260. It just changed, $1,200 just a couple months ago. Now, a lot of times they can go above this, as they should be able to, because caps might limit a legitimate defense that someone might have, and so people who are indigent shouldn't be so limited in being able to assert and have competent counsel. But let's just keep it at the cap just for the purposes of this exercise. So it's $1,200, and then we've got $2,100 in jail fees at about $70 per day. And now we have a subtotal of $4,135. Just to go back, remember, the person who's not indigent starts off with that $835 subtotal. Now we've got $4,135. Because collection fees are percentage-based, and even though the percentage is lower now, it's still percentage-based, you've got a $1,000, more than $1,000 collection fee for the same debt, as opposed to $209, which is what someone who has more resources would have to pay. Because the initial balance is larger, that amplifies the cost of collection, and that brings us up to a grand total for the same exact facts of culpability of $5,169. So you have this disproportionality really based on income level, and it's not sort of an indirect argument, that people who are low income, have more issues and are involved in the system more often. It is a direct mathematical cause. I mean, in addition to all of those indirect causes that I think a lot of us know pretty well. So the current way that court debt is collected at the moment, and what can happen to you if you owe court debt. So I have this chart here that kind of just shows our system, which is very complicated. Although you'll be surprised to hear it used to be way more complicated than this. This is actually the simplified system that we have come up with. Hold on just a moment, I'm going to check the chat. Are people charged for court-appointed attorneys as well? They are charged for court-appointed attorneys. So if you use a court-appointed attorney, then that is going to be charged back to you dollar for dollar, unless you're able to show that you don't have the ability to pay that. That last sentence, you don't have the ability to pay, that is a very complicated issue, which we're going to talk about in depth later. It doesn't necessarily work out the way that we would hope as far as ability to pay, but we'll get into that here in just a few slides. So back to the system. What happens if you do owe court debt? Now we know low-income folks have a much larger burden per case, even based on the same basic facts of culpability. What happens to them? So within the first 30 days, the case remains with the clerk of court. The most recent version of the statute says that you have to owe at least $100 to be eligible for a payment plan, but courts generally don't enter into payment plans with people at this stage, and they let the case for those debts that cannot be paid within the initial 30 days. And again, when we're looking at our, my client here, my client's not coming up with $5,000 at the first 30 days or $4,000 for the subtotal within the first 30 days. So for the most part, what's going to happen is it's going to go to a delinquent court debt collector. And under current law, that's either going to be the county attorney, who can file a notice with the state in order to collect debt for the state, or in the counties where the county attorney is not present, it is the Iowa Department of Revenue. So in the counties, the county attorney can garnish the person in the same way that anyone else could if you owed a credit card judgment or some other kind of civil judgment. They can bring contempt of court action only for non-payment of fines and surcharges, though, and ability to pay is supposed to be an absolute defense. They can revoke supervised release, so parole, work release, or probation. Again, though, ability to pay is supposed to be an absolute defense based on case law that's been on the books for decades. The county attorney or the Department of Revenue can suspend people's driver's licenses if the underlying debt is related to something vehicular. In any case, either the Department of Revenue or the county attorney can suspend someone's ability to renew their vehicle registration. And then the Iowa Department of Revenue can do some things the county attorney cannot. They have access to what's called administrative garnishment and levy. This means that instead of the county attorney doing what most lawyers in civil judgments do and filing a document in the case and giving people an opportunity to have a hearing in front of a judge to try to protect some of their income, this is generally an automated process that has very reduced hearing rights, where it's mostly presided over by non-legally trained staff of the agency, Department of Revenue. In addition, there's another type of collection which is called administrative offset, which is where the state can take payments they would otherwise pay to people, like benefits or tax refunds, and instead apply those back towards the debt that they owe. All right, I'm going to take a quick look at the chat here. Is it possible to get the slide of the chart to us? It'd be helpful for training staff in the process that many of our clients face. I am helpful to, or happy to provide the entire set of slides, including that chart. And I think I have a higher res version of the chart, which if folks want to email me directly, I can send a copy of that. And then someone also sent me an email saying, I thought the driver's license suspension is no longer applicable. No, driver's license suspension is alive and well for non-payment of court debt. And this is an illustration of how to think about how driver's license suspension for non-payment of court debt actually works. So you've got really three types of court debt out there, and they have different effects on people's driving. For court debt that is not related to a conviction, so it comes from a dismissed criminal case or a civil case or a juvenile case. And by the way, civil and juvenile cases and dismissed criminal cases, primarily what people owe in those cases is attorney fees. So in juvenile cases, for example, and we're not talking about delinquency cases, I'm talking about child in need of assistance cases or termination of parental rights cases. You have a right to a court-appointed attorney in those cases, but just like a criminal case, you can be charged back, and they will try to charge you back as much as they can, to the extent that you can't get it reduced based on an ability to pay argument. Civil cases, similarly, a lot of times the debt is coming from counsel fees if someone faces contempt of court for some reason. So say like in a family law case, if someone's saying you're not following the custody decree, they could bring a contempt of court action because jail is a potential penalty. For that, you can have appointed counsel, and that can be charged back to you. But for any non-conviction court debt, they can't take your registration and they can't take your license. For conviction-related court debt, they can put a hold on your registration. And for vehicular conviction court debt, so everything from traffic tickets all the way up to, I guess, vehicular manslaughter, any non-payment of court debt there will bar your ability to get a driver's license. However, a lot of people then in Iowa say, oh, Iowa is sort of has a limited application of driver's license suspension. Unfortunately, what we see a lot is a two-step process where someone can't afford non-vehicular court debt. Let's say it's my client who had the shoplifting charge. She can't pay back that $4,000 debt that we talked about in that illustration. And she drives on expired tags because she can't get her registration renewed. Because she can't get her registration renewed and drives on expired tags, then she picks up a new charge. The new charge is driving with expired tags. Driving with expired tags is a vehicular charge. She can't pay that court debt either. Now her license is suspended. So that is a process we see happen all the time. And so I would say that not only do we have vehicular driver's license suspension for vehicular court debt, I would say that for many people, it should be really construed as non-payment of court debt more broadly, because that is something that really often happens to our clients. So let's talk a little bit about the role of court debt in systemic dysfunction. As I'd mentioned, the Ferguson report in 2014, which was issued by the U.S. Department of Justice, really focused on this role of revenue generation policies as a major driver of abusive policing practices and other kinds of, frankly, legal dysfunction. It was a national wake-up call on this issue. I will say that we were working on it for about 5 years before then, but mostly alone here in Iowa on our own until after Ferguson, at which point I think there was a national group of advocates who kind of came together on this issue. We meet periodically, folks from all over the country, a lot of people from the various ACLUs and the national chapter, the Southern Poverty Law Center generally hosts a conference every 18 months down in either Montgomery or New Orleans. We kind of switch back and forth. And so there's actually a pretty wide network now of both attorneys, but also academics. The Arnold Foundation has been funding a lot of research and also advocacy projects on this issue over the last few years, and continues to do so. Because in many places this remains an issue. Iowa, maybe foremost among those in many ways. And in many cases, Ferguson looked at this issue. What happened in Ferguson, Missouri, and what really drove the problems in Ferguson, Missouri was you had all of these municipalities sort of surrounding St. Louis and the St. Louis area that were independent. And over time, their tax base had decreased as the demand for services increased. And they had no way to be able to pay for that. There were some property tax changes to how property tax was assessed as well that reduced their tax base even further. And so more and more of these municipalities, Ferguson included, but definitely not only Ferguson, turned to these user fees, essentially, and fines as a way of funding government services, and kind of flipped the entire system on its head, where there were incentives being given to folks to collect and assess as much as they possibly could, because that's how city government was funded. However, there are many different ways in which this kind of revenue drive can play out. In Iowa, we have a unified court system, and a lot of our court debt actually goes to the general fund, fines and the repayment for defense counsel does not go back to the defense fund. It goes to the general fund. It doesn't go back directly into the fund that's being paid out. But we have actually Fergusonized our unified court system in that we had created the county attorney collection system, which actually allows for a certain percentage of the funds to be diverted back to the county, and to a certain extent back to the county attorney's offices. If they collect over a certain amount, the county attorney's office that collects directly receives a certain percentage of the take. But the rest of the money comes back to the counties. A lot of counties will also pay a certain share of what is collected back to the county's attorney's office, as well as for other local government, county government functions. So we have a version of that local revenue driver. I often say that the story of court debt is in part the story of property tax reform. I often also too think about the system as being similar to what happened in the foreclosure crisis. In the foreclosure crisis, you had initially this system of buying homes, where the purpose of the system was to enable people to buy homes by allowing them to borrow money at rates that they could repay, which was good for the homeowners because they would be able to get equity, and good for the banks because they would have obligations that could be repaid and were defaulting at an unreasonable rate. Then you add into that equation this completely alien influence, which is the people who are investing in the payments that people make, and it turns into an investment product. And then it creates this drive to get more mortgages, not to get more people to own homes, but the demand really starts coming from investors as opposed to potential homeowners, which sort of flips the entire system on its head and makes it do something it was never designed to do. And in my opinion, what we have here with sort of the revenue drive and using these fees, these user fees as revenue generators, is very, very similar in that it sort of perverted the original purpose of court debt, which was to either punish or to make victims whole, and turned it into something that really is not its original purpose and creates more problems than it solves. So let's talk a little bit about ability to pay. So ability to pay is this idea that there is a constitutional and in some cases statutory requirement that some of these debts, anything other really than fines, surcharges, or victim restitution, can only be assessed to the extent that there's an ability to pay it. is you've got a line of U.S. Supreme Court cases, most notably James versus Strange and Fuller v. Oregon, which basically said, and these are in the context of charging back counsel fees in particular, that you can do it, but it is barely constitutional. And like anything that is barely constitutional that comes up to that line of constitutionality, you can only do it if there's a lot of protections for the people who it affects, kind of counterbalancing that, right? So it's possible to do constitutionally if you design a system that makes sure that it doesn't actually, sorry, here I was looking at the chat. NAACP has a great video on the cost of bail too. I agree. So James versus Strange and Fuller v. Oregon basically said it's barely constitutional. You have to follow certain rules to make sure, one, that you're not treating people more harshly than someone who's, would owe this money in a civil context. Let's say they owed a private market attorney for, the cost of representation. They can't be treated more harshly than that kind of private market situation. And then two, other things in place to make sure that the cost burden for these user fee types of debts like counsel fees never really cause a hardship against people who truly don't have the ability to pay them back. Iowa adopted these standards in a 1977 case called State v. Roberts. And for many years, the rule was that only applied to convictions. But in the 90s, Iowa began collecting debt from people who had dismissed criminal cases and other types of cases. And it wasn't until 2009 that the Iowa Supreme Court ruled that the constitutional requirements of only charging back what someone has the ability to pay also applies to acquittals and vexation dismissals. And then finally, in 2018, the Iowa Supreme Court issued a decision in a case called State v. Albright, which said even though ability to pay had been on the books since the 70s, courts did not really treat it very seriously. And the Albright case basically said, here, we are going to start treating it seriously. There's some constitutional and statutory issues we've got to focus on. And here are the rules. No court debt assessed without an ability to pay determination. And you have to know the entire amount that someone might have to pay before it could be assessed. There's another problem that was happening a lot, which was a lot of times when the case was wrapping up, whether it was a sentencing or being dismissed, you didn't know how much the defendant had picked up in debt over the course of the case, because certain things weren't reported at that particular time. So you didn't know, for example, how much the counsel costs were going to be, because the case wasn't over yet. You were still having the case by the time you were at the end and doing the final stages of the case. And so a lot of times those amounts were reported months after the case was over. In the case of jail fees for people who couldn't afford bail, I've seen cases where those debts were reported and the sheriffs were seeking compensation over a year after the end of the case. So that was a big problem. And State v. Albright basically said, you can't figure out, you have to figure out ability to pay before you assess these, and you can't assess ability to pay until you know how much is owed. So that's the promise of ability to pay. That's been the laws in the books, like I said, for decades. Unfortunately, the disappointing reality is that the collection rate for things like indigent defense or jail fees is very, very low, which indicates that whatever laws we've had about ability to pay, they have not been working. If you look here for the last few years, I've got 2012 to 2020, collection rate has gone from a high of 4.2% of what is owed to something more recent, which is 1.9 or 2.0. This is a pathetic collection rate and indicates that there are a lot of people out there who don't have the ability to pay. This is not all based on willful non-payment. Contrast that to fines. We talked about fines. Fines are charged to people regardless of their income, right? Only poor people owe indigent defense fees. Fines are owed by anyone who gets caught up in the system. Payment rate for fines is much, much higher, which, a good reason for that is that A, people who only owe fines have a much smaller amount to pay in total, and B, fines are charged to a much wider socioeconomic swath of people than a lot of these much more expensive, frankly, user fees. So some of the problems that we've seen over the years, old problems, courts just simply not following the rule, courts just determining that everybody has the ability to pay. And one of the reasons why they didn't follow the rule or just sort of didn't take it seriously is that there were never objective standards as to what it actually meant to have the ability to pay. You basically, and given the lack of standards, just about any set of standards you can imagine have been applied by courts. Everything from just determining anybody who qualifies for court appointed counsel can't afford to pay. We tend to like those. I think that's more realistic for a lot of these situations. To courts who never waive fees just as a matter of principle without really ever considering ability to pay at all, and everything in between. Dismissal debt, which you talked about already, and then very limited opportunities to modify the debt. So one of the problems with court debt, and yet another problem, is that if a court determines, say, that they feel that someone's going to be able to pay this back because maybe they're in their 20s or 30s or something, and then they are in the court's opinion, maybe without much evidence, people who are quote unquote able-bodied and able to work, and so they'll be able to pay back whatever it happens to be. There's really no way to go back and fix it if the court turns out to be wrong, if that speculation turns out to be incorrect. I think there's actually potentially constitutional issues with the lack of an opportunity to modify the debt. For example, in Florida v. Oregon, the U.S. Supreme Court said that it was very important for the constitutionality of these statutes to be able to go back later on if, for example, the court gets wrong or if something changes. You never know what's around the corner. And if there's something that might affect someone's employability or income level that could change later, there's currently no mechanism and has not really been much of a mechanism under the law to be able to change it. There's a limited mechanism for people who are under supervision, but it applies to a small subsection of people who have these issues. So now we're going to talk a little bit about SF 457, which is a new bill that just passed last session. And basically, we had a lot of problems before, but after SF 457, it is much harder, even than it had been before, for people to assert this ability to pay right to be able to reduce this debt. So, for example, before SF 457, there was no initial presumption that someone has the ability to pay. Now, after SF 457, it is the defendant's burden to prove that they don't have the ability to pay instead of the state's burden to prove that they do. Before SF 457, the court had to affirmatively find the ability to pay before court debt could be assessed. Burdens on the state to do that. After SF 457, it is now the individual's burden to do certain things, and within 30 days of sentencing, otherwise they're done. They've waived any ability to pay rights that they may have had. Before SF 457, courts had to give some rationale for how they came to the decision that someone had the ability to pay. After SF 457, courts no longer have to provide any reasons for their decisions, which makes review very difficult. Before SF 457, you had it was treated like other types of appeals. After SF 457, there is a heightened presumption, again, that the district court, the trial court, whatever decision they made was correct. Before 457, the trial court had to know all that was potentially owed. After SF 457, the court can assess ability to pay, even if they don't actually even know how much money possibly the final balance might be. And then some issues with appeals. I have a chat here, which I'm just going to take a quick look at. How does an individual apply to show they don't have the ability to pay? Is this something that Iowa Legal Aid will help with? In some circumstances, yes. The Iowa Legal Aid, we help with collateral consequences cases. So the part of the criminal case that happens after you no longer have a right to counsel. People still need lawyers because they're dealing with these issues for years in many cases after the criminal case is over and your right to have that public defender has detached. And so we help with those cases. We do make these arguments in some cases. But part of what we also do is to educate the criminal defense bar about how to make these arguments in other cases. In fact, we have a training for the criminal defense bar in February where we are going to be training them on ways to make these arguments based on the kinds of things that legal aid does. One of the things about legal aid is that we deal with ability to pay arguments all the time in other contexts. The same principles of what it actually means to survive in Iowa, and those are usually the standards we go for like, so for example, the standards cost of living in Iowa that have been put out by Iowa Public Policy Project and now Common Good Iowa, that actually looks at data and provides sort of an evidence-based, objective set of standards that shows, if you have a family of a certain size, how much does it cost for transportation based on where you live? How much does it cost for rent on average, utilities on average, et cetera? Those are the sorts of arguments that we make. Currently, though, the law doesn't require courts to pay attention to any of that. And so it's, kind of whatever you can persuade a court to do. So that's kind of what we're working with the criminal defense bar on, and then also working on in our own cases. Whether or not it's something that should be handled by Iowa legal aid or a criminal defense attorney really depends on what part of the case you're at and the type of case. Sorry, ask a lawyer a simple question and get a complicated answer. That's what they taught me to do. I've got a lot of student debt piled into coming up with complicated answers to things. What interest groups initiated SF 457? Interesting. I think SF 457 in many cases is a bill that nobody really liked. I know that the county attorneys and the Sheriff's Association had their own version of a bill that did pass the House, but ultimately was not picked up and incorporated into SF 457. Their bill would have just eliminated the ability to pay rights out of the gate. But I know that this was not what they had asked for either. They had their own bill, which didn't pass. Does legal aid handle forfeiture cases? In some cases, we do. We do handle it in some cases. The best thing for people to do is to call, but definitely worth a call in those cases. Okay, so dismissal debt, we talked a little about this. 15 million assessed in cases where all charges were dismissed or someone was acquitted of all charges from fiscal year 2014, 2019. Often people owe more for dismissals than if they're convicted, because a lot of times the deal is you waive your right to ability to pay, and the state will dismiss whatever charges as long as you agree to pay, whatever they say you have to pay. So people who are less criminally culpable pay more than someone in a situation where they're convicted. The statute doesn't actually seem to allow this, yet it's common practice. U.S. Supreme Court is very skeptical of this very recently. I think even the current balance of justices on the court would probably still rule the same way as they did in Nelson v. Colorado. Almost certainly a plurality on this issue. The only justice who Gorsuch recused in that one, Coney Barrett and Kavanaugh weren't on the bench yet, but the rest of the folks I think would still constitute a plurality on the issue. As far as the general propriety of charging debt outside of a conviction when it comes to court debt. The interesting thing about, it's interesting talking about interest groups. The debate about court debt does not cut across traditional liberal conservative lines. There are a lot of folks on all parts of the political spectrum who I think are very focused on the basic sort of injustice of this issue from a civil rights perspective and just the fiscal nonsense that it represents. And we look at that collection rate for some of these things and you think, how much does a policy of charging people who don't have money 5 times as much really make? Is it a policy that's designed rationally to generate revenue? Doesn't seem like it. And the proof it seems to be in the collection rate that it is not working. Now, we're now making it more difficult for people to raise this ability to pay arguments. So my guess is that we're not going to get better. Anyway, there's a lot of folks on the conservative side who, at least at the national level, that are very interested in this issue. And in fact, when we have our yearly conventions for advocates in this area, it is a very diverse, politically diverse group of people. Very interesting to hear all the different arguments and ways people come to this advocacy from across the spectrum. Hold on just a moment here. I've got a couple chats that have built up. Oh, what does ATP stand for? Ability to pay. That's clear. Sorry, another thing about lawyers, we tend to like acronyms. So let's talk a little bit about history of delinquent court debt collection in Iowa pre-2020. The county attorney collection programs that I talked about, where the county attorneys can take a cut of what they collect, began in 91. In 92, courts were given discretion to refer cases to the Department of Revenue. 2010 was really the big change. And just to sort of point out how this doesn't seem to cut across political lines, this was done. And a lot of the worst changes before 2020 happened in a democratically controlled legislature, Democrat governor. So again, these don't really cut across political lines. The interests here, play out in different ways. So 2010, collection and imposition became much more harsh. The courts were basically deprived of any discretion to keep cases with them, to modify court debt, etc. In fact, I would say, just go back to the interest real quick as I'm saying this, in a lot of ways, the dynamics of this in Iowa have been more of a conflict between branches than a conflict between political parties or political ideologies. The legislature versus the judicial branch on issues of funding and revenue, and kind of different views of the judicial branch's role in contributing back to the state fisc. 2015, so in 2010, we created a system where county attorneys were collecting. There was also a private debt collector that the state was required to hire for certain counties, and the Department of Revenue as well, in a very big, confusing mess. In 2015, the state removed the Department of Revenue as a collector and gave the private debt collection agency first cut at all of the debts. And then in 2016, county attorneys pushed back and basically split the state up with the private debt collector into different counties based on the county attorneys, whether or not the county attorney elected to become a debt collector for that state. And that was the situation for 4 years until we got to 2020. And we'll talk a little bit again about some of the other aspects of SF 457 in a minute. But first of all, I'm going to talk about court rulemaking. While all this was going on, the judicial branch started an advisory group, a committee to come up with a better way of approaching court debt. And this committee was comprised of court administrators, judges, and clerks, but had both Iowa Legal Aid and the Harvard Criminal Justice Policy Program as consultants to basically talk about how to write a rule that brought Iowa at least into compliance with current law and best practices nationwide on these issues. So over 2 years, we did design a rule, and the rule, in my opinion, ended up looking pretty good. We, again, were acted as consultants. The rule was mainly designed by judges and other court personnel. However, as of 2021, that process and the rule that we had created was never released for the public. And at this point, it looks like the judicial branch is not planning on taking any further action on it. So even though it was a valiant effort, and I think we came up with a good rule, it will never, at least under that process, see the light of day. However, we are going to be submitting a new version of the rule in July 2021 that is going to, within the bounds allowed by some of the statutory changes, try to suggest ways and codify some ways at the judicial branch level that we can approach this a little bit better in a way that makes more fiscal sense and is more humane. So that is something that we have planned in the future, something to look out for. Let's see, I'm going to skip this because we're running out of time a little bit. I'm going to talk a little bit about an interesting case. Well, actually, I'll go back to this one real quick. Some interesting cases that have come down the last couple of years from the Iowa Supreme Court on this issue. One is State v. Gross. This is about collection of those jail fees. In other words, fees that are charged on a nightly basis for people who can't afford bail or otherwise can't be released. So under the prior version of the law, up until 2020, the sheriff could either elect to treat those as a civil debt or could use the criminal process to collect them. If they don't use the criminal process, that takes some tools off the table for them as far as collecting. However, the attractive thing to a lot of sheriffs was you didn't have to do the ability to pay determination. And when we're looking at specific types of court debt, counsel fees are a big issue. They tend to be hundreds usually often thousands of dollars. Jail fees tend to be higher. It is not uncommon for us to see a 5-figure jail fee debt if someone spent a lot of time in detention prior to trial. The highest amount of jail fees I've ever seen in a single case was just over $50,000. That was a kid who was 16, charged as an adult, and awaiting trial for over a year, and ended up with over $50,000 in debt from a single case. I think his fine in that case was maybe $1,000. So when you just look at sort of the percentage of the debt that's assessed specifically to punish versus the debt that's assessed sort of shift costs, falls more heavily on people in poverty. The difference is extremely stark. So in the Gross case, there was some dispute as to whether or not the sheriff could sort of bypass the ability to pay process by using this civil debt method. And so ultimately the court said, yes, they could, but if they did that, then these debts really did have to be treated as civil debts. So, certain consumer protections would be available. The state wouldn't get to use the advantages that it would normally get by classifying it as criminal in order to use more harsh collection penalties. They would be subject to bankruptcy, et cetera. Dismissal debts. We talked about how a lot of people get debt assessed when the case is dismissed and there's no criminal culpability. And so the Iowa Supreme Court actually did not answer this question back at the beginning of 2020. So the question so the way this case played out is Lori Mathis, who is the defendant in this case, ended up being charged with a minor drug charge, which was enhanced based on some convictions from back in the 90s. Ultimately, the state dismissed the charges, but assessed the attorney fees and other costs to her, which ended up being about $3,000. She appealed that, basically saying she had never agreed to these costs being assessed against her. And the case went up to the Court of Appeals. The Court of Appeals basically said, you have no right to appeal the final outcome of a dismissal of a criminal case. You don't have a right to appeal everything. There are certain things that the law can do to restrict your right to appeal certain things within bounds. And the Court of Appeals, or Intermediate Court of Appeals, ruled that you didn't have the right to appeal a dismissed criminal case. And also, parties can agree to whatever they want. And they found that there was enough in the record to show that there had been an agreement. The Iowa Supreme Court took the case on further review from the Intermediate Court of Appeals and sent out a request for amicus, so a request to organizations to put their legal opinions in to the court about one particular question, which is, does the law even allow for debt to be assessed in a dismissed criminal case in the first place? And Iowa Legal Aid was one of the organizations that submitted an amicus, joining with the Iowa ACLU and a national organization called the Fines and Fees Justice Center, who we've had a lot of interaction with over the years, basically making the argument that there was in fact no jurisdiction based on, one, the way the statute is written, and two, Nelson v. Colorado, which is the US Supreme Court case I mentioned a while back. So what ended up happening is the court split 3-3 on the issue, with Justice McDermott recusing. And so we got one of those decisions that you get when you get an even tie from the Supreme Court that says these justices would have voted yes, these justices would have voted no. We're not going to tell you the reasons, and whatever the lower courts decided gets affirmed by default. So ultimately, in this case, Lori Mathis ended up stuck with the Court of Appeals decision, and we all of us end up with sort of wondering exactly what the Supreme Court would have said and what the justices would have said had the case actually gone up for decision on the merits. So we don't know, and this is an issue that I think is probably going to come up again. I know that this is something that we are currently litigating in a number of ways. So whether it's our case or another case that goes up, this is sort of a major issue right now on the horizon. The 2020 legislative session, talk a little bit more about the history of SF 457. SF 457 actually started as a bill that actually passed in 2019, passed the Senate, held over from the prior session. The original version of it that passed the Senate sponsored by Senator Dawson, was mostly a reform of fines and surcharges. It really didn't deal with any of the ability to pay issues or anything like that. And then in the 2020 session, there were a couple of other bills proposed. One was HSB 658, which was the County Attorney Sheriff's Association bill that simply eliminated the ability to pay for everything except for attorney fees. And then there was SF 2374, which made ability to pay determinations much more difficult for defendants, and then made jail fees civil in nature after July 1st, 2020. So it actually just removed the ability of sheriffs to go after jail fees through the criminal process at all. So that was a bill that was proposed. Then Corona happened, and we didn't know whether or not either one of these bills was going to come up at all, and we kind of hoped that neither one would. But then, unfortunately, what happened was on the last day of the session, SF 457 was amended to include the ability to pay language and the jail fees language from SF 2374, but then a lot of additional language that was added in that had never been part of even SF 2374, including a section replacing the private debt collection firm with the Iowa Department of Revenue. And because we're running a little short on time, I'm just going to go through a couple of the changes from SF 457 we haven't talked about directly, and then I will open up for questions. So I know there's a lot of information too, and I'm a bit of a fast talker. So I'm happy to go back and talk about any of this either today or, if people have questions afterwards, I'm happy to have my email address distributed, and I can try to get to those later on as well. So jail fees. Jail fees, again, one of the major drivers of poverty in Iowa when it comes to court debt. The changes that have recently been made is that jail fees have been removed from the definition of court debt, and now the sheriff has to file a separate civil case, either in small claims or if it's over 6,500 in jail fees in district court. It's kind of strange because normally the sheriff is a neutral actor who plays a role in the civil justice system. They serve process and serve lawsuits on people. They are sort of the neutral party that oversees garnishments or executions of judgments and things like that. However, for these jail fees cases, they are now going to simultaneously be playing that neutral role, and also they're going to be the plaintiff in these cases and act as a creditor in these cases. Yet to see how that may or may not play out in real life as these cases actually get filed. However, the good thing is jail fees after July 1st, 2020, that were assessed after July 1st, 2020, can affect your driver's license. They can affect registration. They don't bar expungement, which is another problem. You can't get expungements of cases until you pay off court debt in general, based on the way the laws are currently written. They can't be made, jail fees now can't be made a condition of deferred judgment, collected through contempt or revocation, supervised release. In other words, they're just another civil debt. And the payment plan minimums, I don't think I need to go into. So we still have no guidance on what ability to pay actually means, which is one of the reasons why we are going to be going back to the court in July and making some proposals, which mostly mirror, again, what the Committee of Judges, Clerks, and Court Administrators came up with, along with Iowa Legal Aid and Harvard Criminal Justice Policy Program between 2018 and 2020. As we look at some other issues as well, though, the jail fees issue, I think we have some concerns about how these cases are going to be going in. Again, there's no ability to pay assessment, so the amounts that people are going to be charged are going to be much higher. I think these debts are subject to civil protections, but I think that's going to take some litigation to actually get sheriffs to understand, because sheriffs are not used to having to plan around and to make sure that they're conducting themselves in ways now that they are sort of more regulated as a civil debt collector. One of the things that's kind of interesting, I think, too, is that to the extent that people who owe this debt are incarcerated, when they're being sued for the jail fees, there is a rule under the Iowa Rules of Civil Procedure that says you cannot, if you are incarcerated or otherwise under a legal disability, such as you're a minor or have are incapacitated for physical or mental health reasons, you can't have a default judgment entered against you unless you're first appointed a guardian ad litem, which is usually an attorney. And so I think one of the questions going forward is how many of these cases are going to be filed against people who are incarcerated and can't really come out and defend themselves in the civil cases, and how valid will those judgments be if there's not a guardian ad litem appointed in these cases for those people. I think it's much higher percentage of these folks who have these filed against them are going to be incarcerated. Another thing that we're starting to see, which is very concerning, is something called a confession of judgment, which is basically the civil equivalent of a criminal confession. Normally, when you are sued in civil court, the other side has to write down the reasons why they think the court should give them what they want, and they have to serve it on you in a way where they can prove that you got it, and you have the opportunity to respond and say the reasons why you think they're wrong, and then ultimately go before a court. Confession of judgment is something that allows one party to skip all of that part and go straight to the part where they can start garnishing you. It is a very old law that we have in the books in Iowa. It's actually part of our territorial code in a pretty substantially similar form. So this law, confession of judgment law, in its current form is older than Iowa itself as a state. In the 70s and 80s, every other state except for Iowa reformed their confession of judgment statute. We are the lone holdout that still has the same version that we had that predates the Civil War. And so there are some serious problems with this. However, I understand that some counties are beginning to use these confessions of judgment as a precondition to release from the jail. So you have to sign something basically saying that you will not, essentially waiving all your rights to contest the judgment. These have been a problem in other circumstances. Iowa has actually been using collection agencies hired by the state of Iowa have been using these to collect student loans that have a connection to Iowa. And we've had several situations with the student loan cases where people have no notice of these being filed and then ultimately end up with bench warrants against them because they're not showing up for debtors exams. So it's a way actually of reincarcerating people essentially for being poor, because there's much less notice and just a much higher chance that you're going to get a debtors exam and a bench warrant issued for yourself. Department of Revenue. So this is something that is going to be a big issue in 2021. Their re-involvement in the court debt process, which ended originally in 2015, kicked in again on the first of the year. The Department of Revenue is going to be collecting court debt in the way they collect taxes, which means in a very aggressive and highly automated way that is rife with problems. We've had a lot of problems with them in the past. Our first court debt cases back in 2009, when I was a new attorney, I was going toe-to-toe with the Department of Revenue all the time on these issues. And we ended up getting, I think, some pretty good, in fact, when they removed the Department of Revenue in 2015 from the process, we were in the process of working out with the Attorney General some changes that we thought actually comported with the Constitution and the law a little bit better. And then, of course, they removed them from the process right at that time. And now we had to pick up the conversation again 5 years later. But some of the things that we saw then that we are worried about now are failure to recognize what are called debtors exemptions. In other words, usually if someone is going to be taking money from you because you owe a debt, whether it's to the government or not, there are laws that protect a certain amount of what you have. And they were instead ignoring those laws and taking up to 80% of people's gross income back in the day. So we had clients who were working 40 hours a week and were homeless because they couldn't get any of the money they were earning. They were using gross earnings rather than disposable earnings to determine what was available, stacking multiple garnishments on top of each other to get close to 100%. Let's see, some of these are things that would take more explanation. Not really engaging in payment plan amounts, reasonable payment plan amounts, because they had the power to basically take everything you had, so why would they be reasonable? And just generally a culture of unreasonableness. I have some more stories that I could share, but it is 11:12, so I won't do that. And a lot of times they had over collection because they were offsetting people's tax refunds and then garnishing them and maybe doing some other things. People were making a payment to get a registration back, and then they would over collect, and getting the money, the overpaid money back from the state was murder. And then also inaccurate statements made to induce collection. So they would often, I think, misunderstand the laws that apply to court debt, and so a lot of their dunning letters would say inaccurate things. So when recently there was a rulemaking in the Department of Revenue that, about assessing a 15% collection fee for court debt referred to the Department of Revenue. And Iowa Legal Aid was one of the commenters, and we submitted a comment at the end of last year, and we asked them to do three things. We asked them to, first of all, reduce the basis for calculating that 15% fee to exclude counsel fees and jail fees, right? Because remember, all the way back, like several slides ago, part of the issue is that poor folks end up paying more because there's certain debts that are only charged to them. But then these percentage-based collection fees make it worse because the initial balance is so much larger. So what we said is, the collection rates are so bad on these, you're not really going to collect the money anyway. Just reduce the misery and only charge the 15% fee on, everything except for counsel fees and jail fees. Just reduce that part of things. And then also we asked for a process for a full or partial waiver of the collection fee based on financial hardship. The department rejected those, basically saying that they felt that they had to assess the full fee. Not much more explanation than that. We did also, in our comment, point out some of the problematic practices, which they are more open to talk about. We're currently in discussions with them on ways to make these practices, less illegal than they were before, frankly, back in the 2009-2015 era. Okay, that's a lot of information. I hope it was useful. I'm around for another 15 minutes if folks have questions. I'll stop sharing my screen now. I want to make sure I got to everything on the chat as well. And given the number of people on the call, which is a lot, it might be good if folks could put information in the chat. Okay, so let's see here. Why do you think conservatives are interested in this? This is a question from a while back. It doesn't make fiscal sense, number one. And two, I think there's been a lot of focus on the conservative side on criminal justice reform in general, because they, I think, there has to be realistic, sanctions have to be realistic. People have to have the ability to re-enter society. And if you load people down with obligations to the point that they can never escape from them, then are you really getting those people back into society and back into, a law-abiding, more productive mode? I think that from a law and order perspective or from an economic perspective, there's that. There's also, I think, the fact that a lot of these user fees look a lot like taxes to people from a conservative perspective, and that is really the almost the main way in which these are being criticized by people like Grover Norquist. I have here something from the Institute for Justice that I have to read, which is called Taxation by Citation. I don't know if you know the Institute for Justice. They're like a libertarian version of the ACLU, essentially. That they do a lot of work on these cases, and might be doing some work in Iowa soon. So those are some reasons. It might be interesting. I know some folks on the national level who speak about this a lot. Greg Glod from the Right on Crime. Mark Levin is probably the most widely known national speaker on this for the Texas Public Policy Institute, who speaks very eloquently about this stuff, probably better than I can from a conservative perspective. Let's see, how is Iowa Legal Aid funded? We are funded through a variety of different means. We have at this point, over 95 different funding sources, many of which are small. Our largest sources of funding are LSC, which is a Legal Services Corporation, a federal corporation, essentially a federal agency that has funded civil legal services since the mid-70s. We also have a state appropriation under the Attorney General's budget. It's a line under the Attorney General's budget. And then a whole host of other grants, for the most part, philanthropy. The Iowa Legal Aid Foundation, just to give a shout out to the foundation, does amazing work in driving philanthropy for Iowa Legal Aid. So a wide variety of different funding sources. League of Women Voters does a lot of advocacy, state level, with contacting legislators to support or oppose legislation. What issues do you suggest we might focus on regarding court debt? So I will have to say that I have some restrictions about how I can answer this question. legal aid, we can talk about the effects of laws or proposed laws, but we can't really actively take steps to tell people to contact legislators. And we can't contact legislators ourselves to tell them what laws to write. We can tell them what we don't like about laws they propose. But so in other words, the federal government, where these restrictions come from, allows us to talk about problems but not solutions, except if we have a direct invitation from a legislator, we can say whatever we'd like. So I can't necessarily answer that question directly. I think that the issues that we've highlighted in this, to the extent that I can talk about problems, I've, in a very quick way, hit on a lot of the different problems that we've seen across the state. I know that it was a bit quick and there was a lot covered, but I would say that what I covered in this presentation illustrates the main ways in which this is really hurting low-income Iowans and maintaining barriers to self-sufficiency and escaping poverty. Review some of the consequences of carrying unpaid debts. Okay, so as we talked about before, some of the things that can happen to you if you have these debts are, one, you are denied certain benefits of that might come out of the criminal justice system or of your citizenship in the state. So, for example, you can't get an expungement of a criminal case unless your debt is paid. That goes for almost every type of expungement except for juvenile and public intox for whatever reason. I think that has to do, the public intox has to do with the fact that that law's old. It was the first type of expungement we had in the books, public intox and underage drinking, the college student crimes, as I call them. And so those have much more favorable provisions than a lot of other types of criminal expungement. But we actually took to the Iowa Supreme Court in 2019 the issue of whether or not they could deny expungement to someone who didn't have the ability to pay counsel fees. And we lost that 4-3, and it was the first case we appealed to the US Supreme Court in over 30 years as an organization. And we made it past the first hurdle, but ultimately did not get cert granted. Maybe an issue for another day. Other things that can happen to people besides no expungement. So if you're on probation, failure to pay back the fees can technically be grounds for revocation of probation, parole, or work release. Now, they can't do that unless they can prove you had the ability to pay and didn't. But there's always this additional danger of going back, and it will extend your probation often to the maximum, whereas people might be able to get off earlier if they're able to pay these things more in advance. Then there's some of the garnishment I talked about, so they can garnish you, either the Department of Revenue or the county attorney, and it can be difficult to protect your income. Driver's licenses on the line for any crime that is vehicular in nature. Registration can be suspended, renewal of registration can be suspended for any court debt related to any conviction, vehicular or no. I know I'm forgetting some things as well. Oh, they can offset your state tax refunds and sometimes payments owed to you by the state. And that's about it at the moment. Oh, contempt of court for fines or surcharges only, which can land you back in jail. Okay. Unfortunately, this is another area of huge disparities for my families in Davenport. Davenport is one of the cities, by the way, in which we operate our expungement clinics. The original cities were Davenport, Dubuque, Des Moines, and Waterloo. And we added Cedar Rapids to the mix back in 2018. And we hope to be able to add more cities and actually have more of a rural presence. One of our next goals is to find some hubs in rural Northwest and Southwest Iowa to be able to help people out in those areas as well. What is the racial breakdown of people represented by Iowa Legal Aid? When it comes to African Americans, it pretty much cuts across the same lines, maybe a little bit more, slightly. I'm not sure if it's a statistical significance based on the poverty population. I don't remember the exact numbers, but it tracks census numbers for the demographics of people in poverty. For Latinx folks, it is lower than the percentage of people in poverty, which I attribute primarily to the fact that we have some restrictions that are imposed upon us by the federal government and not voluntarily imposed based on immigration status. There are certain immigration statuses that we cannot assist people unless they are themselves victims of crimes, human trafficking, or domestic abuse. So that, I think, creates some issues with us being able to represent and give services to a representative sample of people in poverty. For the most part, the racial breakdown of people represented by Iowa Legal Aid matches pretty well the demographic makeup of people in poverty. Now, the sorts of questions and sorts of issues that people bring to us is very interesting because there is a lot of variation. And so for African Americans, for example, housing and collateral consequences were top the list, whereas for other groups, domestic abuse plays a much higher, doing advocacy for victims of domestic abuse and protective orders and family law is a much higher up on the list. And so that's something we've actually been looking at recently is we're going to be doing a legal needs study in the coming year and looking at how our services break down and how well we serve different communities, whether it's racial or folks with disabilities or seniors. Those are issues we're looking very hard at actually this year. Isn't this deliberately affecting people of color the most? We don't have numbers, but in my heart, I know it's true. As I think a lot of folks do. I mean, when you look at the poverty rates, the unemployment rates, and the how we have been either at or near the top of incarceration disparities for Black folks in Iowa over the years, how could it not? Now, whether or not there are actually even more disparities or levels of disparities to be found, we have actually put together some ideas for researchers to take a look at that. We actually have designed a study along with a retired professor of social work at U of I, and we have kind of an out-of-the-box set of ideas. We just haven't found an academic to pick it up yet. I would love to be able to back up what I am convinced is probably true with someone who could actually look at it objectively and gather the data and look at that. But we haven't found any takers on that yet. It is a question that cries out for study though here in the States, especially given the system that we have created, which I think in some ways is much more harsh even than places you would normally think of as being harsh, like the Deep South. We have problems they don't. They have problems we don't too. Let's be fair. But certainly there are things about the Iowa system that need more study. Let's have a copy of the comments and graphics lost through the screen. Thank you for valuable information. Sure, I'll send that along. Do the so-called private jails charge the same fees as public jails? It has to be a county-run facility under the statute. And also, too, it's important to think about the difference between pretrial incarceration fees, which is a problem, and post-trial, so if someone's been sentenced and is in a state institution, the state does allow for fees to be charged for post-sentencing incarceration, so someone's sentenced for 2 years, but that is largely charged through a sales tax to the commissary. It's not directly assessed as sort of a liquidated debt the way the pretrial stuff is. Just learned the commissary thing a few months ago. I had never known that actually, even after working on this for so many years. Getting pulled over for driving while Black, then they find you couldn't pay for the registration. Yeah, I have no doubt. I'm not disputing that at all. I mean, and it bears out what I've seen. I mean, we've represented, like I said, through our clinics. Our clinics are specifically focused on racial justice. We specifically cite them in those communities where the racial disparities and a whole host of factors, criminal justice, one among them, being the highest in Iowa, and based on the stories that we've heard and the general accumulation of experience that we've had with clients in that area, I do not doubt that in any way. Can you email me to get, okay, and I will make sure that anybody who wants the presentation can have it. The legislators ask for your input for legislation. They do, sometimes. And I've come to the end of the chat questions here, and we are at 11:28. So wow, what a great group. I'm so glad that this is something that has generated so many questions and so much interest. Like I said, it's an issue I found to be very compelling over the years, and this is something that I have worked a lot on, and I think unfortunately, as much progress as I feel like we've made and as much fight as we put into it, the current state of things is as bad as it's ever been. And so, which doesn't mean there's no opportunities, and there are some. We're working on some litigation now. In fact, we have talked a little bit about the private debt collector. We have a case in the Southern District of Iowa that is raising some arguments that these debt collectors are bound by certain federal debt collection protection laws that they have sort of flouted over the years. The private debt collector that was operating in Iowa until a few weeks ago, Lineberger, Glagon, Blair, and Sampson. They're a national player based out of Texas. Not a very good reputation nationwide. And so we're working on that, and we have some other things litigation-wise planned, as well as our rule that we're going to be presenting. Anyway, very interesting issue, lots of things, lots of potential, even though there are also lots of problems. So I want to make sure that we keep the chat log here, because there's some people who are sending their email addresses directly. I'm not sure, Alan, what you think the best way of getting the materials out to folks is. I don't know if you have a list of the people on this list, but I'm fine. None of this is private. These are all views that I've expressed publicly on a number of occasions. And
Al, do you have an idea how we can do this? I'll tell you what, Alex, the rest of us the folks who are kind of leading this will get together and figure out the best way and be back in touch with you. I think that's probably the best.
Okay, so I'll go ahead and just send the slides then that I have together to Alan.
Sounds
now,
good.
Since I have his email address. Okay, thank you very much for having me. Like I said, I'm really gratified to see everybody's interest in this. It's very important.
Thank you ever so much. We have so much to think about now. We're going to go ahead and close this meeting for today. The League of Women Voters Criminal and Justice Committee continues to be active. If you have comments that you would like to send, you could do them through the League's website, or folks you might know on the committee, your local president, many ways you can get a hold of us. So thanks for being a part of this, and have a good day.